Welcome to HOA Violation Vault. She treated my curb like a towable offense. I opened my garage and Vanessa was already there yelling that I pushed snow into the road, and the HOA was fining me per incident, unless I shoveled it back immediately. Your ice is the problem, and you are fixing it. She was standing in the middle of my driveway, holding up a bright phone case like it was a badge, her breath coming out in angry clouds, and I had not even backed my car out yet. I work rotating shifts at the water treatment plant, and I was already running behind. The snow had fallen overnight, maybe 6 inches, and the city plow had done its job at 4 in the morning while I was asleep. I did not touch the snow. The plow pushed it, but Vanessa did not care about facts. She stepped closer and jabbed a finger toward the street. You pushed that pile into the road and it is blocking the storm drain and the mailbox access, and I am filing 3 separate violations right now. I looked past her and saw the snowbank. It was maybe 2 feet high, sitting exactly where the city plow always leaves it, right at the edge of my property line. I said I did not plow anything. The city did it. She snapped back that the city does not service Lakewood Terrace Association driveways, and that I was responsible for everything that touches my curb. I said that is not how municipal snow removal works. She pulled out her phone and started typing. Fine schedule is $50 per day per violation starting today, and if you do not clear it by noon, I am escalating to the towing list. I felt my jaw tighten. Towing list. I said, what towing list? She smiled and said the emergency winter enforcement list, authorized under the amended rules we passed in November. I said I never got any notice about amended rules. She said ignorance is not an excuse, and that I signed the bylaws when I bought the house. I did sign them, but I also read them, and there was nothing in there about towing cars over snow the city plow left behind. I asked her to show me the section. She said she did not have to show me anything and that I could look it up on the portal myself. Then she turned and walked toward the street, stepping carefully over the ice, and called back over her shoulder that I had until noon. I got in my car and backed out slowly, avoiding the snowbank. I was already 10 minutes late and my supervisor had made it clear after my last tardy that one more would trigger a formal write-up. I am still on probation at this job and I cannot afford to lose it. I drove to the plant, clocked in, and spent the first hour of my shift thinking about that snowbank and the imaginary towing list. At break, I logged into the HOA portal on my phone. The portal is a mess. Half the links are broken, but I found the rules section and downloaded the master document. I searched for the word tow. Nothing. I searched for winter enforcement. Nothing. I searched for emergency. 1 hit. Buried in a section about hurricane evacuation procedures, and it had nothing to do with snow. I took a screenshot and then I called my cousin Derek, who is a local attorney. I know him through family and he has helped me before with lease disputes. I explained the situation fast, reading him the exact words Vanessa used, and he said it sounded like she was inventing rules. He told me to document everything, take photos of the snowbank with a timestamp, and get a copy of any notice she sends. He also told me to check if the HOA has a management company, or if the board is self-managed, because that changes who I can escalate to. I said I would find out, and then I hung up and got back to work. When my shift ended, I drove home and found a red stamped final notice envelope tucked into my door frame. I opened it in the driveway. The letter inside had the Lakewood Terrace Association letterhead and 3 line items. Violation 1, obstruction of storm drain. Violation 2, obstruction of mailbox access. Violation 3, failure to maintain clear pedestrian path. Each one listed a $50 daily fine starting today, and at the bottom it said that if I did not remedy the violations within 24 hours, my vehicle would be subject to removal under Emergency Enforcement Authority. I read it twice. The letter was printed on official HOA stationery and signed by Vanessa Thompson, Architectural Committee Chair. I took photos of the letter, and then I walked to the curb and took photos of the snowbank from every angle, making sure the timestamp was visible in the corner. The snow was melting a little in the sun, but it was still a solid 2-foot pile. The storm drain was half blocked, but the city had not cleared it yet anyway. The mailbox was accessible if you walked around the pile. The pedestrian path was the sidewalk on the other side of the street, which had nothing to do with my property. I sent the photos to Derek and asked him if this counted as harassment. He texted back within a few minutes. Yes. Also, the towing threat is likely outside her authority unless the HOA has a specific lien or court order. Ask her to produce the rule in writing. I went inside and drafted an email to Vanessa, using the address on the portal. I kept it short and factual. I wrote that I received her notice, that I reviewed the governing documents and found no emergency winter enforcement provision, and that I was requesting a copy of the specific rule she was citing. I attached a photo of the snowbank with the city plow tracks visible. I hit send and then I sat down and ate a cold dinner, watching the clock. My next shift started at midnight, and I needed to leave by 11:15 to make it on time. At 10:30, I got a reply from Vanessa. The email was 2 sentences. You do not get an opinion, you get a fine schedule. Compliance is mandatory and enforcement begins immediately. I stared at the screen. That was it. No rule citation, no documentation, just a threat. I forwarded the email to Derek and added a note. She is refusing to provide the rule. What do I do? He called me 5 minutes later. He said that if she follows through on the towing threat without a valid rule or a court process, it could be conversion, which is a tort. He told me to send one more email creating a clear paper trail, stating that I dispute the fines and that any towing action would be unauthorized. He also told me to set up my phone to record if she shows up again, because her behavior sounded erratic and I might need evidence later. I sent the email and then I left for work. The snowbank was still there when I backed out of my driveway. I drove to the plant and started my shift, but I kept checking my phone during breaks. No new messages. At 4 in the morning, I got a text from my neighbor across the street, a guy named Tim who works from home and keeps odd hours. The text said Vanessa just tried to get into your driveway with some kind of traffic cones. I called him immediately. He said he was up getting water and saw her car pull up around 3:30. She got out, walked to my driveway, and started placing orange cones across the entrance, blocking it off. He went outside and asked her what she was doing. She told him it was HOA business and that she was securing a violation site. He told her she could not block someone's driveway and she said she could under emergency authority. Then she got back in her car and left. The cones were still there. I felt my chest tighten. I thanked Tim and told him I would handle it. Then I called Derek again, even though it was 4 in the morning. He picked up on the 3rd ring, groggy but awake. I told him what happened, and he was quiet for a second. Then he said that blocking my driveway was likely criminal, not just a civil dispute. He told me to call the non-emergency police line and report it as a property access issue, and to remove the cones myself and document it. He also said to start writing down every interaction with Vanessa, because this was escalating fast and I might need a restraining order or an injunction. I finished my shift at 8 and drove home. The cones were still there when I pulled up. I got out, moved them to the side of the driveway, and took a photo of each one. They were standard orange traffic cones with no markings. I stacked them by the curb and then I called the non-emergency line. The dispatcher took my information and said an officer would come by later that morning to take a report. I asked if I could file for harassment and she said that would depend on the pattern of behavior, but that I should document everything and request a case number. I went inside and slept for 3 hours. When I woke up, there was another red-stamped final notice envelope on my door. I opened it standing in the doorway. This one was shorter. It said that due to continued non-compliance, my vehicle registration had been flagged for towing, and that I should contact the management office immediately to arrange payment. There was a phone number at the bottom. I called it. A woman answered and said Lakewood Terrace Association Management Office. I said I received a towing notice, and I needed to know what rule it was based on. She put me on hold for 2 minutes, and then came back and said she did not have any record of a towing authorization, and that I should contact the board directly. I said I was contacting the board. Vanessa Thompson sent me the notice. The woman paused and then said that Vanessa was architectural committee chair, but that towing authorizations had to come from the president or the management company, and that she had not received any request. I asked her to confirm that in writing, and she said she would send me an email. I hung up and sat down at my kitchen table, staring at the notice. Vanessa had no authority to order a tow. She was making it up. I called Derek and told him. He said that was good news for me and bad news for her, because if she actually followed through and called a tow company, it would be conversion and possibly fraud. He told me to keep the notice, keep the email from the management office, and bait her into putting it in writing one more time so we had a clear pattern. I sat there thinking. Then I logged into the HOA portal and looked up the board roster. Vanessa was listed as Architectural Committee Chair, appointed by the board president. The president was a man named Greg Holloway, and there was a phone number listed. I called it. He picked up after 4 rings. I introduced myself, told him I lived in the subdivision, and said I was getting conflicting information about winter enforcement rules. He sighed and said that Vanessa had been overzealous lately, and that the board had not passed any new winter rules. I asked him if there was an emergency towing list. He said no. I asked him if Vanessa had authority to order tows. He said no, and that if she claimed she did, I should report it to him immediately. I thanked him and hung up. Then I forwarded him the 2 red-stamped final notice envelopes as scanned attachments, along with the email chain where Vanessa refused to provide the rule citation. I wrote a short cover note. Greg, I am attaching documentation of enforcement actions taken by Vanessa Thompson over the last 48 hours. She has threatened to tow my vehicle under a rule that does not exist and has blocked my driveway with traffic cones. I have contacted the management office and they confirm there is no towing authorization on file. Please advise. I hit send, and then I sat back and waited. An hour later, I got a reply from Greg. He apologized for the confusion and said he would speak to Vanessa immediately. He also said that any fines or enforcement actions related to snow removal were suspended pending a full board review, and that I should not receive any further notices. I felt a small flicker of relief. Then I checked my email again and saw a new message from Vanessa, sent directly to me and not copied to anyone else. The subject line was final warning. The body said that I was in breach of multiple covenants and that she was forwarding my case to a collections agency unless I paid the outstanding balance of $300 by the end of the week. The fees were listed as 2 days of fines across 3 violations. I called Derek immediately. He was in court, but he texted me back, "Do not pay. Forward her email to the board president and the management company. If she sends it to collections, dispute it with the agency and threaten a lawsuit for wrongful collection. Also, check if she is using a personal email or an official HOA email." I checked. It was her personal email address. I forwarded the message to Greg in the management office with a short note. Vanessa is now threatening collections for fines that you confirmed are suspended. This is harassment. Please stop her. I hit send, and then I went to take a shower, trying to calm down. When I got out, my phone was buzzing. 2 missed calls from Tim, my neighbor. I called him back. He said Vanessa just showed up at my house again with a man in a truck. The truck had a tow company logo on the side. They were standing in my driveway taking photos of my car and measuring the distance to the curb with a tape measure. Tim said he went outside and asked them what they were doing, and Vanessa told him to mind his own business. The tow driver looked uncomfortable, but he kept taking notes. Tim said they left a few minutes ago, but that he got a photo of the truck with his phone. I thanked him and told him to send me the photo. Then I called Derek again. This time he picked up. I told him what happened, and he was silent for a beat. Then he said that was it. Vanessa had just committed conversion by attempting to arrange an unauthorized tow. He told me to call the tow company immediately, explain that the tow was not authorized by the HOA or any legitimate authority, and request a copy of the dispatch log showing who called them. He said if Vanessa called them herself, that was proof of intent and we could use it in court. I looked up the tow company using the logo in Tim's photo. I called their dispatch line and told them my name and address. The dispatcher said they had a service request logged for that address this morning, but that it was canceled before they dispatched a truck. I asked who requested it. She put me on hold and then came back and said the request came from a Vanessa Thompson, who identified herself as HOA enforcement. I asked if I could get a copy of the dispatch log and the call recording. She said she would have to check with her supervisor and that I should submit a written request. I said I would and thanked her. I hung up and called Derek. I told him the tow company confirmed Vanessa called them and that I could get the dispatch log. He said perfect. That is your trump card. He told me to request the log in writing, get the recording if possible, and sit on it until the right moment. He said do not tell Vanessa you have it. Do not warn the board, just let her keep digging. I asked him what the right moment was, and he said probably a board meeting or a formal hearing, somewhere public where she cannot control the narrative. I nodded even though he could not see me and said I understood. I nodded like I accepted it, because I wanted her comfortable and careless. That afternoon, I drafted a formal records request to the tow company, citing my right to access dispatch logs related to my property. I sent it via email with a read receipt. Then I went back to the HOA portal and downloaded every document I could find. Bylaws, covenants, board meeting minutes, committee charters, everything. I spent 2 hours reading through it all. There was nothing about emergency winter enforcement, nothing about architectural committee towing authority, and nothing about collections for disputed fines. Vanessa had made it all up. I also found something interesting in the board meeting minutes from November. There was a line item about proposed rule changes for snow removal, but the motion failed to pass because only 2 board members voted yes. Vanessa was not a board member. She was appointed to the architectural committee, which meant she had no voting power. The rule she was trying to enforce did not exist because the board rejected it. I took a screenshot and added it to my evidence folder. That night I worked another shift at the plant. When I got home at 8 in the morning, there was a new notice taped to my garage door. This one was handwritten on HOA letterhead. It said that my driveway access was suspended due to ongoing violations, and that I was required to park on the street until further notice. It was signed by Vanessa with a date and timestamp from 6 that morning. I took a photo and then I walked to my car, which was parked in my driveway where I left it. Nothing was blocking it. I got in and backed out, then pulled forward into the driveway again, just to make a point. I called Greg Holloway, the board president. He picked up and I told him about the handwritten notice. He sounded exhausted. He said that Vanessa was not responding to his messages and that he had called an emergency board meeting for tomorrow night to address her behavior. He said I was welcome to attend and present my evidence and that the board was taking this seriously. I thanked him and said I would be there. Then I called Derek and told him about the meeting. He said it was good timing, but that I should also prepare for Vanessa to escalate one more time before the meeting, because people like her do not back down quietly. He told me to keep my phone charged, keep recording if she shows up, and do not engage with her directly. I said I would. If you are enjoying this story, hit the like button and subscribe so you do not miss what happens next. The next day I woke up around noon and checked my email. There was a message from the tow company with an attached PDF. It was the dispatch log, showing 2 calls from Vanessa Thompson requesting a tow for my address, both marked as canceled. The first call was logged at 3:40 in the morning on the day after the first red-stamped envelope. The second call was logged yesterday morning, right before the handwritten notice. Both calls listed the reason as HOA enforcement and unauthorized parking. I saved the file and forwarded it to Derek with a note. Got it. He replied immediately. Do not share this with anyone until the meeting. Let her think she is safe. That evening I drove to the HOA clubhouse for the board meeting. The parking lot was half full, which was more than I expected. I walked inside and saw about 20 people sitting in folding chairs facing a long table where the board members were seated. Greg Holloway was in the middle. Vanessa was sitting off to the side in a chair by herself, scrolling through her phone. She looked up when I walked in, and her face went tight. She stood up and walked toward me. I stopped near the door and pulled out my phone, holding it low like I was checking a message, but I had the recording app open. She stopped a few feet away and said, "You should not be here." I said it is an open meeting, and I have evidence to present. She said the meeting agenda is closed and that I was not invited. I said Greg told me I could attend. She stepped closer and lowered her voice. You are not the first person I have corrected, and you will not be the last. Every single one of you thinks you can ignore the rules and then complain when there are consequences. I stayed quiet and let her keep talking. She said I had 24 hours to pay the outstanding fines, or she was filing a lien against my property and forwarding my case to the HOA attorney. I said the fines are not valid, and you know it. She smiled and said, "Prove it." Greg stood up and called the meeting to order. Vanessa turned and walked back to her seat. I sat down in the back row. Greg went through the standard opening items, approvals and minutes and treasurer report, and then he said the board had received multiple complaints about enforcement actions related to winter snow removal, and that the board was suspending all related fines and penalties pending a review. Vanessa stood up immediately. She said she had been enforcing the rules as written, and that the board had no authority to overrule her committee. Greg said the architectural committee does not have enforcement authority, and that all fines have to be approved by the full board. Vanessa said that was not true, and that the charter gave her discretion. Greg said, "Show me the charter." Vanessa pulled out a binder and flipped through it, then stopped and pointed at a page. She said it was right there, Section 4, Enforcement Discretion. Greg took the binder and read the page. Then he looked up and said this section is about architectural review timelines. It has nothing to do with fines or towing. Vanessa said he was misreading it. Greg handed the binder back and said the board was suspending all enforcement actions she had taken in the last 2 weeks, and that any homeowner who received a notice would be refunded. Vanessa turned red. She said that was not fair and that she was doing her job. Greg said your job is to review paint colors and fence applications, not to invent rules and harass residents. Vanessa looked around the room and then she locked eyes with me. She pointed at me and said he is the one who started this. He has been defying every rule since he moved in, and I am done letting people like him get away with it. I stood up and said I have not defied any rules. I have asked you to show me the rules you are claiming to enforce, and you have refused every time. She said I do not owe you an explanation. I said you owe me documentation, and so does this board. Greg said we are going to hear from everyone. Sit down. I sat down. Greg asked if anyone else had complaints about Vanessa's enforcement actions. 3 people raised their hands. One man said Vanessa had fined him for parking his truck in his own driveway because it was too big. Another woman said Vanessa had threatened to report her for a dead plant in her front yard. A third man said Vanessa had sent him a letter demanding he repaint his mailbox because the color did not match the approved palette. But when he checked the palette, there was no such color listed. Greg listened and took notes. Then he said the board would be conducting a full audit of all enforcement actions taken by the architectural committee in the last 6 months, and that any invalid fines would be reversed. Vanessa stood up again and said she was not going to sit here and be attacked. She said she had spent hundreds of hours volunteering for this community, and that the board was undermining her authority. Greg said, "You do not have unilateral authority. That is the problem." Vanessa grabbed her binder in her bag and walked toward the door. She stopped next to my chair and said, "This is not over." Then she left. The room was silent for a few seconds. Greg cleared his throat and said we were going to take a short break. During the break, I walked up to Greg and introduced myself properly. I handed him a printout of the tow company dispatch log and the email chain where Vanessa threatened collections. I also showed him the screenshot of the November board minutes showing that the snow removal rule failed to pass. He looked through the pages and his face went pale. He said this is worse than I thought. I said she tried to order a tow on my car twice, both times unauthorized, and she is still threatening to file a lien. Greg said we are going to fix this, but I need you to present this evidence formally, so it is on the record. I said I will. The meeting resumed. Greg said he wanted to address the specific complaints related to my property and asked me to come forward. I walked to the front and stood next to the table. Greg asked me to explain what happened. I started with the morning Vanessa confronted me in my driveway and went through the timeline. The first notice, the blocked driveway with the cones, the second notice threatening towing, the collections threat, the handwritten suspension of my driveway access. I kept it factual and calm. Then I said I have documentation for all of it, including proof that Vanessa called a tow company twice to remove my vehicle without HOA authorization. I handed Greg the dispatch log. He read it and then passed it to the other board members. One of them, a woman in her 50s, said this is illegal. Greg nodded. He said Vanessa called a tow company and misrepresented her authority, which means the HOA could be liable if the tow had gone through. He looked at me and said I am sorry this happened, and the board is going to take immediate action. He asked if I had any other evidence. I said yes. I also have a recording of Vanessa threatening me in the parking lot 20 minutes ago. I pulled out my phone and played the clip. Her voice came through clearly. You are not the first person I have corrected, and you will not be the last. The room was completely silent. Then one of the other board members, a younger man, said we need to vote on this right now. Greg said agreed. He said the board was voting to remove Vanessa Thompson from the architectural committee effective immediately, to void all fines and notices she issued in the last 2 weeks, and to revoke her access to the HOA portal and any administrative tools. He asked for a motion. The woman in her 50s made the motion. The younger man seconded it. Greg called for a vote. All 5 board members raised their hands. The motion passed unanimously. Greg looked at me and said, your fines are void, your access is restored, and if you incur any costs related to this situation, submit them to the management company for reimbursement. He also said the board would be drafting a formal apology letter and that I could request a copy of tonight's meeting minutes for my records. I thanked him and sat down. The rest of the meeting was procedural. Greg announced that the board would be forming a compliance oversight subcommittee to prevent this kind of abuse in the future, and that all enforcement actions would require dual approval going forward. When the meeting ended, I walked out to the parking lot and saw Vanessa sitting in her car staring at her phone. She looked up and saw me. She rolled down her window and said, "You think you won." I kept walking. She called after me, "You just made yourself a target." I stopped and turned around. I said, "I have everything on record, Vanessa. If you contact me again, if you send me another notice, if you even look at my driveway, I am filing for a restraining order and I am suing you personally." She stared at me for a long moment. Then she rolled up her window and drove away. I went home and called Derek. I told him what happened at the meeting, and he said it sounded like a clean win, but that I should still be prepared for Vanessa to retaliate in some other way. He told me to keep documenting, keep the dispatch log safe, and follow up with the management company to make sure the portal access was actually revoked. I said I would. The next morning, I got an email from the management company confirming that Vanessa's administrative access had been revoked and that all fines associated with my account had been removed. The email also said the board had adopted a new enforcement checklist that required all violation notices to include a specific rule citation, photographic evidence, and dual board approval before any financial penalty could be assessed. I forwarded the email to Derek, and he replied with one word: Perfect. That afternoon, I was shoveling the driveway, clearing the fresh snow that had fallen overnight, when Tim walked over from across the street. He said he heard what happened at the meeting and that half the neighborhood was talking about it. He said Vanessa had been terrorizing people for months and that everyone was relieved she was finally stopped. I said I was just glad it was over. He said it was not over yet, because Vanessa was still on the board's email list and she was already sending group messages claiming the board had violated her rights. I asked him to forward me the messages. He pulled out his phone and showed me. The messages were unhinged, accusing the board of conspiracy and retaliation, and demanding a formal hearing to reinstate her position. I called Derek again. He said Vanessa was spiraling and that I should stay out of it unless she contacted me directly. He also said I should consider filing a formal complaint with the county if she kept harassing other residents, because what she did might qualify as extortion under state law. I said I would think about it. A week later, I got a call from Greg Holloway. He said Vanessa had filed a lawsuit against the HOA claiming wrongful termination and defamation. The lawsuit named the board, the management company, and me personally. I felt my stomach drop. Greg said the HOA's insurance would cover the board and the management company, but that I might need my own attorney. I called Derek immediately and told him. He said, "Do not panic, the lawsuit is probably frivolous and it will get dismissed, but that I should file a counterclaim for harassment and intentional infliction of emotional distress." He said he would represent me and that we would use the tow company logs and the recordings as exhibits. 2 weeks later, I was served with the lawsuit at my house. I read through it. Vanessa claimed that I had defamed her at the board meeting by falsely accusing her of illegal conduct, and that the board had conspired with me to remove her from her position. She was seeking damages for emotional distress, lost volunteer opportunities, and reputational harm. The filing was 20 pages long and full of inflammatory language. I gave it to Derek, and he read it in silence. Then he said, "This is a slap suit. She is trying to intimidate you into dropping your complaint." He said we were going to file a motion to dismiss and a counterclaim, and that we would ask the judge for sanctions if the lawsuit was found to be frivolous. Derek filed the motion and the counterclaim a week later. The counterclaim laid out everything: the unauthorized tow attempts, the harassment, the fabricated rules, the threats, the blocked driveway, the collections threat. Derek attached the dispatch log, the recordings, the email chains, the board meeting minutes, and affidavits from Tim and 2 other neighbors who had witnessed Vanessa's behavior. He also attached a copy of the HOA bylaws showing that Vanessa had no enforcement authority. The counterclaim asked for damages, attorney fees, and a permanent injunction barring Vanessa from contacting me or entering my property. The case was assigned to a judge and scheduled for a hearing. The hearing was set for a Monday morning at the county courthouse. I took the day off work and met Derek in the hallway outside the courtroom. He said the judge had read both filings and that he was skeptical of Vanessa's claims. He said our best move was to let her talk first and then drop the dispatch log and the recordings when she tried to defend her actions. I said okay. We walked into the courtroom and sat down at the defendant's table. Vanessa was sitting at the plaintiff's table with an attorney I did not recognize. She glared at me when I walked in. The judge entered and we stood. The judge sat down and called the case. Vanessa's attorney stood up and gave an opening statement, claiming that Vanessa had been performing her duties as a volunteer and that I had orchestrated a campaign to humiliate her. The attorney said the board meeting was a kangaroo court and that my evidence was fabricated. I kept my face neutral. Then Derek stood up. He said that Vanessa's lawsuit was baseless and that the evidence would show she had engaged in a pattern of harassment, fabrication of rules, and unauthorized enforcement actions that crossed the line into illegal conduct. He said the tow company dispatch log proved that Vanessa had attempted to arrange an unlawful tow, and that her own words, recorded at the board meeting, demonstrated her intent to retaliate. Derek handed the judge a binder with all the exhibits. The judge flipped through it for several minutes. Then he looked up at Vanessa's attorney and said, "Do you have any evidence that your client had authority to order a tow?" The attorney hesitated and said the authority was implied by her role on the architectural committee. The judge said, "Show me where it says that in the HOA governing documents." Vanessa's attorney opened a folder and pulled out a copy of the bylaws. He flipped through it and then stopped. He said it was in the enforcement section. The judge said, "Read it out loud." The attorney read the section. It said the architectural committee shall review and approve applications for exterior modifications and shall report violations to the board for enforcement action. The judge said, "So the committee does not have enforcement authority. The board does." The attorney said that was a matter of interpretation. The judge said, "No, it is a matter of plain English." The judge looked at Derek and said, "Do you have the dispatch log?" Derek said, "Yes, Your Honor." He handed the judge a highlighted copy. The judge read it and then looked at Vanessa. He said, "Did you call this tow company?" Vanessa said, "Yes, but I was acting on behalf of the HOA." The judge said, "Did the board authorize the tow?" Vanessa said, "No, but I had discretion." The judge said, "You did not have discretion, and calling a tow company to remove someone's vehicle without authority is conversion." He looked at Vanessa's attorney and said, "I am dismissing the plaintiff's claims with prejudice. I am also granting the defendant's motion for sanctions and awarding attorney fees. If your client contacts the defendant again, I will issue a restraining order." Vanessa stood up and started to say something, but the judge cut her off. He said, "Sit down." Then he said, "I am also issuing an injunction barring you from initiating any enforcement actions against the defendant or his property, and barring you from serving on the HOA board or any committee for a period of 5 years. Vanessa's face went white. The judge said this case is closed. He banged his gavel and stood up. Vanessa grabbed her bag and walked out of the courtroom without looking at me. Her attorney followed her, looking defeated. Derek turned to me and smiled. He said that went better than I expected. I said thank you. He said the injunction means she cannot touch you, and the 5-year ban means she cannot terrorize anyone else in the neighborhood either. I felt a wave of relief wash over me. We walked out of the courthouse and stood on the steps in the cold sun. Derek said I should send a copy of the court order to Greg Holloway and the management company, just so everyone knows the situation is resolved. I said I would. That afternoon, I emailed Greg and attached the court order. He replied within an hour. He said the board was relieved and that they were implementing the new enforcement checklist immediately. He also said the board had voted to refund my attorney fees from the HOA's reserve fund, since the lawsuit was a direct result of Vanessa's misconduct while acting in an HOA role. I thanked him and said I appreciated it. The next week, I received a check from the HOA for the attorney fees, along with a formal apology letter signed by all 5 board members. The letter acknowledged that I had been subjected to harassment and illegal enforcement actions, and it outlined the steps the board was taking to prevent similar incidents in the future. The steps included the enforcement checklist, mandatory training for all committee members, and a new dispute resolution process that required mediation before any legal action. I also got a handwritten note from Tim, my neighbor. He said the neighborhood group chat had been blowing up with people celebrating Vanessa's ban, and that several residents had filed formal complaints with the board about her past actions. He said the board was now reviewing every fine and enforcement action from the last 2 years, and that a lot of them were being voided. I texted him back and said I was glad it helped. A month later, I was out front shoveling again after another snowfall, when a mail carrier stopped at my mailbox. She looked at me and said, "You are the guy who took down the HOA lady." I laughed and said I guess so. She said good, because she used to yell at me about where I parked the truck when I was delivering mail, and I always had to explain that I was a federal employee and she had no authority over me. She said Vanessa once tried to block her truck with cones, and she had to call her supervisor. I said that sounds about right. The mail carrier handed me my mail and said thank you for dealing with her. I said no problem. That night I got a text from Derek. He said Vanessa's attorney had reached out asking if I would agree to a settlement to drop the counterclaim in exchange for Vanessa paying my remaining costs and signing a non-contact agreement. I asked Derek what he thought. He said it was up to me, but that the court had already ruled in my favor and the injunction was in place, so the settlement would not give me much more than I already had. I said I was fine with closing it out if it meant she would leave me alone for good. Derek said he would draw up the agreement. The settlement was finalized 2 weeks later. Vanessa paid the remaining attorney fees and signed an agreement stating that she would not contact me, enter my property, or initiate any HOA action against me for any reason. The agreement also required her to send a written apology, which arrived a few days later. It was brief and clearly written by her attorney, but it acknowledged that her actions were inappropriate and that she had no authority to order the tow. I filed it with the rest of the documents and moved on. The HOA held its annual meeting in March. Greg Holloway announced that the board had completed the enforcement audit and voided over 40 fines issued by Vanessa, totaling more than $15,000. He also announced that the board was drafting new bylaws to formalize the enforcement process and prevent any single person from wielding unchecked power. Several residents stood up and thanked the board for taking action, and one woman said she had been ready to sell her house because of Vanessa's harassment but was now staying. The meeting ended on a positive note, and I felt like the neighborhood might actually be livable again. I still see Vanessa occasionally when I am driving through the subdivision. She does not look at me, I do not look at her. The red stamped final notice envelopes stopped arriving. The gate access works. The parking spot is always available. The snowbanks pile up every winter and the city plow does its job, and no one threatens to tow my car. I still have the dispatch log saved on my phone just in case, but I have not needed it. Derek checks in every few months to make sure Vanessa is honoring the agreement, and so far she has. The neighborhood feels different now. People are less afraid to push back when something does not make sense. The board is more transparent. The enforcement checklist is working. And every time I see one of those orange traffic cones on the side of the road, I smile a little, because I know Vanessa is not allowed to touch them anymore. I appreciate you coming back.